morning, students. This is Sreekanth signing in for Company Law. Previously, we have read Companies Act 1956, which has been repealed by Companies Act 2013. Now we are reading Companies Act 2013. Here, certain sections of the Companies Act 2013 has not yet been notified. So, the sections which have not yet been notified, you have to refer to Companies Act 1956. That means you have to keep Companies Act 1956 plus Companies Act 2013 while dealing with Companies Act 2013. Apart from Companies Act 2013, we have to resort to Insolvency and Bankruptcy Code 2016. So, this Companies Act regulates all the companies in India. So, Companies Act pertains to all the companies that has been established in India, and every company has to invariably follow the Companies Act 2013. So, let us go into the details of a company. What is meant by company? The definition given by the Companies Act we will analyze, and so on and so forth. So, let us go into the definition of a company. In fact, the company may be defined as a group of persons associated together to achieve some common objective. In fact, this is not the legal definition, right? So, a company, it's a voluntary association of persons formed to achieve some common objectives, having a separate legal entity, independent and separate from its members, with a perpetual succession and a common seal, and the capital divisible into transferable shares. So, it's a voluntary association of persons. They are coming together to achieve some common objective. Now, what happens when they forms a company? It will have a separate legal entity, independent and separate from its members, with a perpetual succession and a common seal, and with capital divisible into transferable shares. This is the definition as revealed by the Companies Act. In fact, it is only a legal or artificial person recognized by the law. Now, let us analyze the definition given by the Companies Act 2013. So, this is the definition given by the Companies Act 2013. According to section 2, subsection 20, company means a company incorporated under this act or under any previous company law. So, we have already analyzed this definition. Incorporation or registration is very important to become a company for its existence. Now, let us go into the characteristics of a company or advantages of incorporation. Once a company has been registered with the registrar of companies, it assumes certain characteristics, and it is also known as advantages of incorporation. Let us go one by one. So, the characteristics of a company are: number 1, separate legal entity; 2, perpetual succession; 3, separate property; 4, capacity to sue and being sued; number 5, common seal; 6, members have limited liability; and 7, shares are freely transferable. These are the main characteristics. So, very important characteristics. Once a company has been registered, it assumes the character of separate legal entity. So, this separate legal entity, it is an important characteristics of a company, that it has a separate legal entity. It means what? The existence of a company is independent and separate from its members. So members in the company are not one and the same. Remember, in law, the company is regarded as an artificial legal person which deals in its own names. Thus, a member of a company cannot be held liable for the acts of a company even if he holds the substantial part of the company's share capital. Even one member holds entire share capital of the company does not belong to that shareholder. Why? It has a separate legal entity from its members. Now, let us go into the second characteristics. It is known as perpetual succession. So, the term perpetual succession means continuous existence. A company has a perpetual succession. That means company never dies. The membership of a company may change from time to time, but it does not affect the company's continuity. In other words, the members may come and go, but the company can go on forever. So, as a company is created by the process of law, it can also be brought to an end by the process of law. That means a company comes to an end when it is wound up according to the provisions of the Companies Act. Company has come into existence by operation of law. When you want to wind up the company again, it should be by the process of law. Unless and until court gives an order for winding up, the company has its perpetual succession. That means company does not come to an end even if all its members die. On the death of a member, his legal representatives becomes entitled to the shares by way of transmission. That means company's existence is continuous. Company never dies. It goes on and on and on. Let us go into third characteristics. It is known as separate property. So we know that company is a legal person in the eyes of the law. Now, legal person, that means it can hold the property in its own name. All the property in the name of the company is its separate property, which is controlled, managed, and disposed of by the company in its own name. It implies what? The company is the owner of its assets and capital. The members cannot claim to be the owner of the company's property. Now, a member does not have even an insurable interest in the property of the company. He cannot insure company's property in his own name for its or for his own benefit. Although the company's entire capital, assets are contributed by its shareholders, they are not the private and joint owners of the property. So, once the company comes into existence, it have a separate property being held in its own name. Even though the entire share capital has been held by one member also, it does not belong to that member. Now, going into the fourth characteristics, it is capacity to sue and be being sued. Again, we know that company is a legal person and it has independent existence. So, it's a legal person. It can act on its own. Being a legal person, the company can file suit against others in its own name. Similarly, the suit against the company can also be filed in the company's name. So, it can sue any person can sue the company. It is the fourth important characteristics, capacity to sue and being sued. Coming to next important characteristics, it has a common seal. So we know that company is a legal person, but it is not physically in existence. That means it cannot sign its own name. Now it has a common seal which is used as a substitute for its signature. The common seal is the official signature of the company. As a matter of fact, every company must have a common seal with its name engraved on the same. The company being not physically in existence, it acts through natural persons who are the directors of the company. So whenever a company is issuing shares, share warrants, debentures, bonds, whatever it may be, it has to affix the common seal on its every document. That means if common seal has been affixed on every document, it means that company is signing the same documents. This is another characteristics. Number 6 is its members have limited liability. As a matter of fact, it is the principal advantage of carrying the business under limited companies. Here, a company may be limited by shares or limited by guarantee. In a company limited by shares, the liability of the member is limited to the extent of nominal value of the shares held by him. If the shares are partly paid, the liability of the member is limited to the extent of unpaid value of the shares held by them. And if the shares are fully paid, the liability of the member is nil. So, members have limited liability. For example, assume that a company has issued share, one share is rupees 10. So entire share value is rupees 10. If you paid rupees 6 on the shares, your liability is only 4 rupees. You cannot pay beyond 10 rupees. That means your liability is limited to the nominal value of the shares held by you. So how much amount you have paid? You have paid 6 rupees. What is the share value? 10 rupees. You have to pay remaining 4 rupees. Now, in a company limited by guarantee, the liability of the member is limited to such amount as the member may undertake to contribute to the assets of the company in the event of the company being wound up. That means when you are signing the share application, you are signing that whenever company goes into liquidation, I will pay additional amount. That means you are giving guarantee. So that is known as company limited by guarantee. Now coming to next characteristics, shares are freely transferable. You know that capital of a company is divided into parts and each part is called as a share. The shares of a company are freely transferable and can be purchased and sold in the share market. So, if you read the Companies Act, it tells shares or debentures or other interest of any member in a company shall be a movable property transferable in the manner provided by the Articles of Association. So, shares of the company are transferable like a movable property. Every member is free to sell his shares in the open market and get back his investment without having to withdraw the money from the company. This provides liquidity to the investor. Shares are freely transferable. Remember, in a public company, shares are transferable. However, the private company may restrict the transfer of shares in accordance with the provisions of the Articles of Association. Let us capitulate once again. So, company means a company incorporated under the Companies Act 2013 or under any other previous law, and the company has to be registered with Registrar of Companies by filing two documents. One is known as Memorandum of Association, another one is Articles of Association. And once a company has been registered, it acquires certain characteristics, namely separate legal entity, perpetual succession, separate property, capacity to sue and being sued, common seal, members have limited liability, and shares are freely transferable. The students, got something today. This is Sreekanth signing off today, and tomorrow going into some other topic. Have a good day.